I'm happy to talk about the recently completed project, which I think has, I think it's made an important contribution to extending the public debate and discussion of this issue. I think that's part of what we're all trying to do here is open up a broader discussion of the implications of using the criminal law to regulate sexual HIV risks. And this project in particular is best understood as a law reform intervention. It's a piece of research that tries to use evidence as a way to suggest new ways of thinking about the issue and as a way to inform policy discussion. And it's meant to intervene in the administration of the criminal justice system in the province through its recommendations. I can't really speak a lot about it because we won't have enough time, but I've got the website there, so if anything I say is of interest, you can go to the website and read the report. And I have, I think, 5 copies left. There were some at the back, and I took them away and brought them up here. So if anyone is really, really interested, you know, you can read the report yourself. So who was involved? A fabulous group of people, big brains, lots of commitment. Thanks go to everyone, in particular the writing team, Glenn Bedridge, who was took the lead on the legal analysis, and David McClay, who took the lead on the science analysis in the report. We had a fabulous expert advisory committee. We made use of the reviews from Doctors Call and McPherson on our science, and the project itself was funded by the OHTN. So what were we trying to do? You know, most of you, I'm sure, are familiar with the kind of media coverage that stands in as the sort of main form of public discourse on the issue. We wanted to try to intervene in that and create a new way of thinking about, try to contribute to ways of thinking about the issue that depart from the sort of good versus bad debate. The report has a strategic function. It is trying to reach out to the ministry with its recommendations, and in general is trying to promote limits in the use of the criminal law by introducing an evidence-based sort of approach to the issue. And the report does 3 main things. It characterizes the problem. It offers 4 types of research evidence that can be drawn upon in thinking about the issue, and makes some recommendations. So I'm just going to try to quickly go through some of that so that you get a sense of what the document is like, and then if you're interested, you can follow up. Excuse me. So the problem, basically, that the way we outline the problem is one that emphasizes the expansive use of the criminal law in the context of considerable uncertainty about the legal test that requires disclosure. And that leads to a great deal of uncertainty on the part of people living with HIV about what behaviors place them at risk of prosecution. Not a good situation. So in working through that problem, we deal with 4 forms of evidence, so we have created and reviewed 4 forms of evidence. The first is a set of descriptive statistics. When we started the project, there really wasn't a lot of stable or information about who's being charged, what's happening, what does it look like over time, that kind of stuff. So we put together a database and generated a series of descriptive sort of statistics, and I'll show you some of that to sort of characterize the phenomenon, right? We need to know what this phenomenon looks like at the level of basic, data. Then we undertook an analysis of how the courts have interpreted and used the significant risk test, which points to considerable inconsistencies in that use, which then further helps us to make arguments about the lack of fairness in the law. One of the big issues here has been that courts have lagged behind the science of HIV. There's been a lot of developments in the science of the risks of the science of HIV transmission risk, and what we've tried to do in this report is bring that research to bear or enter it into, try to make it more available and internal to legal definitions of what significant risk is, so that those decisions could be more informed by current and up-to-date science. And lastly, we did create some research evidence on the impact of criminalization on people living with HIV and service providers in the Toronto area. So just quickly with some pattern data. So here we have cases plotted over time for Ontario. And so you can see that there's a period of relative inactivity followed by a real jump in 2004 that is sustained to the present. So there is clearly a process of intensification of criminal charges happening. In terms of regional distributions across the country, it's very clear that Ontario is the sort of epicenter of criminal prosecutions. As Ray mentioned, this is a phenomenon that is highly gendered. There are very important gendered relations of power that organize this issue. And so we can see here that the majority of men charged, majority of people charged in Ontario have been men. Of those 42 men indicated here, 32 have been charged for non-disclosure in sexual relationships with women. Racialization is also a very important part of this issue. Here we can see that there's a large proportion of charges that involve Black African Caribbean men. This is for the full period from 1989 to 2009. But when we look at more recently, at the last 5 years, we see something a little different. Here we have, of all, looking only at heterosexual men charged for that period, we can see that 50% of cases involve Black defendants. And it's important to recognize that there's work being done on racialization on this issue by the African and Caribbean Council on HIV and AIDS in Ontario, and Akeem is here and he can probably speak to that during the question period. In terms of the disposition of cases, we can see here that the majority of cases in Ontario have resulted in convictions either through guilty pleas or through court decisions. So just as a quick overview, the key patterns are an overwhelming representation of heterosexual men among defendants, underrepresentation of MSM, but I didn't show you this, but there's been an increase in cases involving MSM over the last 4 years. In the last 4 years of men charged, 41% have been MSM, and that contrasts with 21% of MSM overall for the entire period. So these kinds of patterns, they don't explain anything, they just sort of, they're descriptions of phenomena. They require explanation, right? And to do that requires further research and a consideration of multiple factors, which we can talk about later. I'm not going to talk about the legal analysis, except to say that, you know, what we did, and if you're interested in looking at the discrepancies in how courts have understood significant risk, right? If you want to look at the cases and see, oh, here's one where they didn't get any evidence about whether risk took place in making the conviction, or here's how they understood it here, and here's the way this evidence was used, or the kind of evidence that was used here, then the report does that in very great detail, and Glenn did a fabulous job of that. And so these are the main forms of inconsistency that we were able to come up with, or identify. I won't speak as well, also I'm not going to speak a lot about this part of the work, but it's actually really kind of amazing. We spent months and months and months doing this work on trying to figure out a way to represent the complexity of current scientific research on the risks of HIV transmission. So if you want a discussion that will take you through that science and apply it to this issue, the report does it in a very nice way. This is the kind of analysis that's provided. There's a discussion of the main risk estimates for sexual transmission, then the factors that reduce the risk of transmission, and estimates that are related to the factors that increase the risk of transmission. And this is all done as a way to try to counter what is characteristically an overestimation of the risk that you find when you read some of the court decisions, right? The judges and juries are often have this sort of really way overblown sense of the ease with which HIV can be transmitted. So we're trying to counter that with some evidence. And the final point there is an anachronistic understanding in the courts as well, for the most part, about what it means to live with HIV. We're trying to show that it's not the immediate death sentence that it's often, in the way that's often framed by court decisions.